The High Court of Kenya, sitting as a constitutional court, has a limited jurisdiction. I know that is not a popular view, but it is the correct view in law, in my humble submission. The High Court of Kenya, sitting as a constitutional court, has a limited view. And that view is to entertain constitutional controversies brought to it by parties who have standing before the court and where a clear course of action exists. There is nothing in the Constitution of Kenya 2010 that said you can come to court if you have no nexus with the dispute, if you have no standing, if there is no course of action. You can write a big petition, throw it to the court and say, please help us because we are very annoyed with the action of the chief. That is not the law of Kenya. What then is the law of Kenya? If you look at what the judges in the Superior Court did, 9 out of 10 of what constitutes their order is an opinion. It is an advisory opinion. They say, we have reviewed as scholars and jurists and thinkers about the law, and we find this basic doctrine theory applies to Kenya. Who has that controversy? Who has that controversy? There isn't a controversy. There is an invitation by the petitioners for the High Court to sit as a philosophical tribunal and interrogate philosophical ideas and then declare whether they apply to Kenya.
Professor,
that is not...
Counsel,
yes.
Wasn't there a claim that there was a threat of violation of the Constitution?
There was a threat, sir, of a...
Were the petitions based on the perceived threat or violation of the Constitution? Did that give them footing?
No, no, sir. No, my lord. It cannot give them footing because I think it is right for the High Court to say, we are squatters in Uhuru Park, but we've been here for 20 years. The government wants to build the office of the Attorney General inside the park. We apprehend that we will be removed without any measures being taken to protect us and our children. Give us an order to stop that being done until a transitional process is done. If I were a judge, I would issue an order. That is a concrete dispute between concrete parties about a concrete property. Here, these very learned applicants are merely inviting the court that please let us engage in a debating, let us have a debating session in the High Court, convert the court into a philosophical forum, and then we ask ourselves, what is the basic doctrine question? Does it apply in Kenya? Has it applied in other countries? Has it been rejected in others? So at the end of the day, should it apply to Kenya? Nobody of them is touching on the Constitution. Nobody is saying sections, nobody. So at the end of the day...
Professor, is that entirely correct? The question is coming from here.
Correct me, my lord.
Is that entirely correct? If you look at the petitions that were before the court, were they not saying that here is a process that is happening, and this process is violative of certain premises of the Constitution, and that if this process goes to its final conclusion, it is going to alter fundamentally the essence of the constitution that was agreed on and passed in 2010, and that cannot happen because what then happened is not an amendment, but basically it amounts to a replacement of the constitution. Are you entirely fair to the judges to say they just sat as a philosophical tribunal and dealt with matters all out there in the air without something concrete on the ground?
What I was trying to do, my Lord, was to draw a distinction between where the court is trying to stop something that potentially may happen, and with it happening, there would be a violation of the Constitution. Here, we have a legislative process, a referendum process, that is inchoate. And it's like saying that the court has issued an order to the Speaker of Parliament. Let me remind you, my Lord, when I was in the Guy Commission, we were writing the chapter on the judiciary. And the late Justice Moijo Kewa and a number of judges came to their own court, filed their own suit, and an order was given to them telling the commission that I was a member of not to discuss the chapter on the judiciary. Needless to say, that order was not capable of obedience. It was not capable of obedience, nor was it, in my very humble view, well-founded in law. It was a terrible case of judicial overreach, not to mention a terrible conflict of interest matter. In this matter, and I associate totally with my learned friend James Orengo, with whom I have not argued a matter on the same side for 20 years. So I am quite happy with this recent development. I am quite happy to associate with James Orengo's very, in my very humble view, very well thought out argument that a political process must be permitted to evolve politically. And a judicial intervention commends itself where that process is complete and a legal product exists to which the judges then say, this cannot be allowed to stand. Let me give you an example. One of the proposed changes is to bring in a judicial ombudsman. I personally don't know whether that is good or bad or whatever. But I can possibly see a day, if this referendum was successful, where somebody would come and say, I am attacking only that section, because as it reads now, it is inconsistent with that section, and it undermines that framework. That would be a jurisdiction that I personally would entertain and would say the judges are the best people to speak about that. So, to my very humble view, the judges exercised a jurisdiction that the people of Kenya reserved for the Supreme Court. Only the Supreme Court of Kenya can issue an advisory opinion. The High Court decided to give advisory opinions on hypothetical issues, coached in the language that it did. As a result, it trampled upon the independence of IEBC. And I want to repeat that, my Lord. Independence is not for the judiciary alone. Independence is for every constitutional institution. Parliament is independent, the president is independent, and all these commissions are independent. That is why the Auditor General is independent, and so on.